In a world where change is the only constant, Mo Shamil stands at the forefront, guiding title professionals to not just grow their businesses, but to master the art of innovation. With every episode, you're handed the keys to unlock unparalleled growth and stay ahead of the curve. Get ready for a transformative journey.
You know that feeling when you finally sit down at the closing table to buy a piece of real estate?
Oh, yeah. The endless mountain of paperwork.
Right. The predictable rhythm of it. You expect the signatures, the hand cramps from signing your name 50 times.
Absolutely.
But you also expect that when you hand over the money and get the keys, the transaction is, well, fundamentally between you, the seller, and maybe the local county clerk recording the deed.
Yeah, it's a private exchange bound by local property laws.
Exactly. But over the last few weeks, if you stepped into the world of cash purchases and corporate entities, that predictable closing table suddenly morphed into like a front line for national security.
It really did. The paperwork wasn't just about who owned the property anymore.
No, it was about federal surveillance. And then, just 4 days ago, on March 19, a sudden legal earthquake struck the U.S. real estate market.
Yeah.
Completely upended that new reality.
Upended is almost an understatement.
Right, because today is March 23, 2026, and the industry is just reeling from a massive collision between the federal government, local small businesses, and the federal courts.
We're looking at the absolute definition of regulatory whiplash here.
Yeah.
I mean, we have a situation where a sweeping federal mandate, one designed to track trillions of dollars, has crashed headfirst into constitutional challenges.
And it led to two different federal courts looking at the exact same law and coming to completely opposite conclusions.
Literally opposite.
Okay, let's unpack this. Because before we get to the Texas judge who just, ripped this rule up, we need to understand what the Financial Crimes Enforcement Network, or FinCEN, actually activated on March 1, 2026.
Right, because for those few weeks, the rules of buying a house changed dramatically.
They really did. FinCEN rolled out the Residential Real Estate Rule. We'll just call it the RRE rule for this deep dive.
Good call.
And it targeted a very specific but massive slice of the market. We're talking about non-financed, so cash, residential real estate transfers to legal entities or trusts.
Right. So if you bought a house with cash, meaning, no traditional bank loan was involved, and you deeded that property to an LLC, a partnership, or a trust, you triggered this reporting requirement.
And FinCEN wasn't just asking title companies to, check a box acknowledging an LLC bought the property.
No, not at all. The rule mandated that title and escrow professionals pierce the corporate veil.
Which is huge.
It is. They had to turn over highly sensitive information about the beneficial owners of those entities.
So we're talking Social Security numbers, unexpired government IDs, the private internal documentation of trusts.
Yep, and hand it all over to the Treasury Department.
The scale of this is just hard to wrap your head around.
Yeah.
Based on the advisories from groups like the American Land Title Association, or ALTA, we're talking about an estimated 800,000 to 850,000 transactions caught in this dragnet every single year.
Every year.
And the compliance cost. The tech provider, Qualia, and legal firms like Foley and Lardner were looking at projections somewhere between $428.4 million and $690.4 million.
In the first year alone.
Right. If you think about the friction that adds to a local title office, it's staggering.
Right.
But I think it's important to note, the Treasury didn't deploy this rule just to make life difficult.
No, they didn't. There is a deeply serious vulnerability they are trying to plug.
Right.
And what's fascinating here is the sheer mechanics of how illicit finance flows through the $55 trillion U.S. housing market.
$55 trillion, that's a lot of places to hide money.
Exactly. The FinCEN Coalition, which is an advocacy group heavily focused on corporate transparency, they laid out the stakes pretty clearly. For decades, the U.S. real estate market has been a premier destination for drug cartels, global syndicates, and foreign adversaries looking to launder dirty cash.
And the mechanism is actually quite simple, isn't it?
It really is. A bad actor sets up an anonymous shell company in a state with loose corporate reporting laws.
Okay.
They take illicit cash, maybe from overseas, maybe converted through cryptocurrency, and they use that anonymous LLC to buy a piece of American real estate outright.
So no bank is ever checking their funds.
Right. And once they own that house, they can rent it out or turn around and sell it, Suddenly, that dirty money is clean.
Wow.
It is fully integrated into the legitimate U.S. financial system, and local law enforcement has absolutely no idea who actually owns the property.
And globally, the U.S. has been failing to stop this.
Yep.
I mean, the Financial Action Task Force, the International Anti-Money Laundering Watchdog, they recently assessed the United States and handed down a flat 0%.
0%.
0% on technical compliance for gatekeepers. Gatekeepers being the real estate professionals, lawyers, accountants who facilitate these transactions.
Right. The global consensus was basically that the U.S. had left the vault door wide open.
Which is why FinCEN decided to escalate. Because prior to this RRE rule, FinCEN relied on geographic targeting orders, right, GTOs.
Yes, GTOs. But they were highly surgical. They only applied to specific high-risk metropolitan areas like Miami or Manhattan.
And they had distinct price thresholds, too.
Exactly. You only had to report a cash purchase if it was over $300,000 in most targeted counties, or say $50,000 in a place like Baltimore.
So the RRE rule essentially took those targeted restrictions and just applied them to the entire country.
Yes. No geographic boundaries, no minimum purchase price.
So if you transferred a property to an LLC for $0 in rural Idaho, it got caught in the exact same reporting requirement as a $10 million penthouse in New York.
The exact same one.
It's like the government traded in a targeted fishing pole for a massive trawling net. Instead of looking for specific fish in specific ponds, they decided to scoop up the entire ocean of cash buyers.
That's a great way to put it. And that transition from targeted enforcement to a universal mandate brings us to the people actually forced to run those background checks.
Right, the small businesses.
Because FinCEN wasn't doing the data collection themselves. They were demanding that local title and escrow agents do it for them under threat of severe civil and criminal penalties.
Which moves us from the government's macro-level national security strategy down to the reality of the people throwing the net. Because the sheer burden of this rule provoked a massive legal backlash.
It really did.
Enter Celia Flowers and her daughter, Erica Hallmark. They own East Texas Title Companies.
Which is not a small operation. They operate across more than 80 counties in Texas.
Yeah, Celia is a textbook self-made entrepreneur. Built her agency from the ground up, starting in the early 90s. And when this rule was finalized, they were looking at a devastating new operational cost just to facilitate everyday property transfers.
And the friction wasn't just financial either, it was structural. Think about the legal analysis provided by the firm Bowditch regarding how this federal dragnet clumsily interacted with local state laws.
Okay.
Let's look at estate planning. Say you own a home in Massachusetts and you want to transfer the deed into your own personal trust for estate planning purposes.
Okay, pretty standard stuff.
Very standard. You aren't selling it. No money is changing hands. Now, under the federal RRE rule, there was supposedly a narrow exemption for this.
Right. If you transfer a property for zero consideration to a trust where you are the grantor, you shouldn't have to report to FinCEN.
Exactly. But state property laws don't always neatly align with federal agency definitions.
Right.
Bowditch pointed out a massive flaw here. Zero consideration deeds aren't actually valid in Massachusetts.
Wait, really?
Yeah. State law requires some nominal consideration to be listed for the deed to be legally binding, even if it's just a formality.
Oh, wow. So because of that quirk in state property law, the federal exemption is completely eviscerated.
Completely. Suddenly, a family doing standard, harmless estate planning in Boston gets caught in FinCEN's crosshairs.
And the law firm or title agent handling the paperwork faces federal penalties if they fail to collect and report the family's sensitive data.
Exactly. It highlights the core friction perfectly.
You have an administrative agency in Washington writing broad rules that crash into 50 different sets of state property laws.
Yes.
And that friction is exactly what drove Celia Flowers and Erica Hallmark to fight back. They partnered with the Pacific Legal Foundation, or PLF.
They're a nonprofit law firm that represents clients pro bono in cases concerning government overreach.
Right, and they sued FinCEN in federal court.
They did. Flowers Title Companies, LLC v. Besant. They argued that the RRE rule is unconstitutional on multiple fronts.
What were the main arguments?
Well, PLF built their case primarily around the Fourth Amendment and the separation of powers.
Okay.
They argued that the government cannot force private businesses to conduct systematic, warrantless surveillance on Americans who are just conducting legitimate transactions. They also argued that Congress never actually gave FinCEN the authority to sweep up this much data from ordinary citizens without reasonable suspicion.
And honestly, I really have to push back on FinCEN's core premise here myself.
Right.
Does paying cash for a house through an LLC automatically make someone suspicious?
It's a fair question.
I mean, there are countless legitimate reasons for this. What if a buyer just sold a business and wants to deploy that capital into real estate without taking on today's massive interest rates?
Or doing some standard tax planning?
Exactly. Or what if a high-profile individual or, even just someone who has dealt with a stalker wants to use an LLC to keep their home address off public county records?
Privacy is a valid concern.
Right. Why does financial success or a desire for basic physical privacy get categorically labeled as suspicious by a federal agency?
If we connect this to the bigger picture, that tension traces back to the foundational law FinCEN relies on, the Bank Secrecy Act.
The BSA.
Yeah. The BSA was crafted in the 1970s primarily for traditional financial institutions, banks that already monitor complex flows of money and have massive compliance departments.
Right, not a local title shop in East Texas.
Exactly. Now, the law allows the Treasury to require reporting on consumer transactions, but the Pacific Legal Foundation argued that the Bank Secrecy Act only allows the regulation of objectively suspicious transactions.
The operative word being suspicious.
Yes. The law does not give the executive branch a blank check to demand the private data of millions of Americans simply because that data might theoretically be useful to law enforcement someday.
And here's where it gets really interesting. That specific debate over the definition of the word suspicious is the exact fulcrum that Judge Jeremy D. Kernodle used to dismantle the rule.
Yes, in the Eastern District of Texas.
Right. On March 19, he issued a summary judgment. And he didn't just trim the rule or limit its scope. He vacated it entirely.
He fundamentally rejected FinCEN's statutory interpretation. FinCEN went into court arguing that all non-financed residential real estate transfers to entities are categorically suspicious inherently because illicit actors sometimes use that method.
Which is wild.
The judge thought so too. He found that logic to be, in his words, vague, conclusory, and unpersuasive.
It's an incredible leap of logic by the agency. I mean, if you define suspicious as anything a bad guy might potentially do, then holding cash is suspicious. Buying a prepaid gift card is suspicious.
Exactly the point the court made. Judge Kernodle noted that holding property in an LLC or a trust is a routine, unremarkable feature of the American economy.
Yeah.
It is standard tax planning. It is standard liability protection. By itself, it does not equate to money laundering, and therefore it does not meet the threshold of suspicious required by the Bank Secrecy Act.
But FinCEN knew that definition was stretched thin, right? They had a backup argument ready. They pointed to Section 5318A to the Bank Secrecy Act.
They did. That section gives the Treasury the power to require financial institutions to maintain appropriate procedures, including the collection of certain information.
Right. So FinCEN argued this section gave them the latitude to mandate the reporting.
Yes, but Judge Kernodle applied a strict textual analysis. He ruled that the statute allows FinCEN to require reporting procedures, meaning the internal compliance mechanisms a business uses.
Okay.
It does not grant the agency the power to invent brand new, freestanding, substantive reporting obligations out of thin air.
Ah, I see. Procedures versus obligations.
Exactly. The judge noted that if Section 5318A gave FinCEN unlimited power to demand any data they wanted, the rest of the Bank Secrecy Act, including the requirement that transactions actually be suspicious, would be rendered completely meaningless.
Makes sense. So the Texas federal court drops the hammer, vacates the rule nationwide, and you would think the real estate industry can finally take a breath.
You would think.
But we have to look at the massive curveball thrown just 1 month prior. Because in February 2026, a federal judge in the Middle District of Florida looked at a nearly identical challenge to this exact same rule.
Brought by Fidelity National Financial.
Yes, Fidelity National Financial v. Besant. And that Florida judge ruled the exact opposite way, entirely upholding FinCEN's authority.
This raises an important question about the current state of administrative law in the federal judiciary.
Seriously.
You have 2 federal district courts analyzing the exact same regulation and the exact same text of the Bank Secrecy Act and arriving at contradictory conclusions.
You're crazy.
The Florida court likely looked at the broader legislative intent of the Bank Secrecy Act, which is to prevent money laundering, and afforded FinCEN much wider latitude to define the preventive measures necessary to fulfill that mission.
Right.
They deferred to the agency's expertise regarding the threat of shell companies. The Texas court, conversely, refused to defer to the agency, binding them strictly to the plain text of the word suspicious.
It is a profound judicial collision. Depending entirely on which state a judge happens to sit in, this reporting rule is either a vital, perfectly legal national security tool desperately needed to stop global drug cartels,
Right.
or it is a blatantly illegal, unconstitutional violation of the Fourth Amendment that turns local businesses into proxy surveillance agents.
And that collision leaves the people actually closing real estate transactions today in a perilous state of limbo.
So what does this all mean for the industry right now?
Well, let's talk about the mechanics of this Texas ruling, because Judge Kernodle vacated the rule under the Administrative Procedures Act, or APA, that vacatur operates universally.
Meaning it doesn't just apply to Celia Flowers in Texas.
Exactly. It wipes the rule off the books nationwide. As of right now, title agents and escrow officers are legally safe from liability if they do not file these beneficial ownership reports with FinCEN.
Okay, so they're safe for today.
For today. However, the legal analyses coming out of firms like Foley and Lardner suggest that no one should be shredding their compliance manuals just yet.
No, definitely not.
Because of the conflicting Florida ruling, and because tracking anonymous real estate is a massive priority for the Treasury Department, FinCEN is almost certainly going to appeal the Texas decision to the Fifth Circuit Court of Appeals.
Right. And when they appeal, they can ask the appellate court for a stay.
Yes. Meaning they ask the higher court to pause the Texas judge's ruling while the appeal plays out.
It's like your teacher canceling a massive term paper the day before it's due, but warning you they might change their mind tomorrow. Do you throw your notes in the shredder? Of course not.
Exactly. Because if the Fifth Circuit grants that stay tomorrow, reversing the pause, that federal mandate instantly springs back to life.
And if you have already fired your compliance crew and dismantled your data collection infrastructure, your entire operation is caught completely exposed, facing federal penalties.
Which is why the guidance coming down from the top of the industry is heavily defensive. The American Land Title Association, ALTA, they immediately issued an advisory to their members urging a cautious approach.
What does that look like in practice?
They are actively telling title companies to continue collecting all of this sensitive information from buyers, the social security numbers, the trust documents, the IDs, just in case that stay is granted, and they suddenly have to backfile those reports to FinCEN.
Wow. And we are seeing that exact same defensive posture on the technology side too. Look at Qualia, one of the major software providers for the title and escrow industry.
Yeah, right.
When this rule was announced, Qualia invested heavily in building a free end-to-end FinCEN reporting tool directly into their core platform.
So their users could actually comply with this massive mandate without drowning in administrative costs.
Exactly. And right now, Qualia is advising their clients to keep that data collection machinery fully operational. You do not tear down the infrastructure while the courts are still fighting over the blueprints.
It forces the local title agent into a terrible position.
It really does.
They have to look their client in the eye and ask for deeply personal data, knowing a federal judge just ruled the government has no right to demand it, but doing so anyway because another court might reinstate the mandate tomorrow.
And to connect this back to you, the listener, if you are listening to this right now and you're closing on an all-cash property through an LLC today, your title agent is very likely going to demand your social security number and your private trust documentation.
Yeah, they almost certainly will.
And they aren't doing it to violate your privacy. They're doing it because they are trapped in the crossfire of a constitutional battle between the administrative state and the judiciary.
To synthesize what we've unpacked here, we are witnessing a monumental stress test of the American legal system.
Yeah, we are.
On one side, you have the FTT Coalition and the Treasury Department highlighting a completely valid, multi-trillion-dollar national security vulnerability where foreign adversaries and cartels exploit state-level corporate secrecy to hide illicit wealth in U.S. real estate. On the other side, you have the Pacific Legal Foundation and small business owners highlighting the severe constitutional danger of allowing unelected agencies to bypass the Fourth Amendment and mandate the warrantless surveillance of everyday citizens conducting routine business.
It is a flawless example of two competing, entirely legitimate interests colliding at top speed. And just as a reminder, we aren't taking sides here, just mapping out this fascinating terrain. And right now, everyone is just waiting on the appellate courts to break the tie between Texas and Florida.
But stepping back from the immediate mechanics of the Bank Secrecy Act, there is a much deeper current running beneath this entire debate.
Oh, what's that?
As data collection becomes more integrated and as artificial intelligence makes it absolutely effortless for financial systems to instantly connect the dots between our bank accounts, our property records, and our core identities, we are rapidly approaching a threshold.
A threshold.
Yes. In an increasingly automated digital age, does the legal definition of what is suspicious need to fundamentally expand so law enforcement can catch sophisticated global networks? Or does our definition of privacy need to fundamentally harden to protect citizens from an inescapable algorithmic federal dragnet?
Man, that is the exact tension sitting across from you at the closing table. Thank you for joining us on this deep dive. Keep examining the structures around you, stay fiercely curious, and the next time you are sitting there, pen in hand, looking at a mountain of real estate paperwork, you might just find yourself wondering, who exactly is looking back?
In a world where change is the only constant, Mohs Shamil stands at the forefront, guiding title professionals to not just grow their businesses, but to master the art of innovation. With every episode, you're handed the keys to unlock unparalleled growth and stay ahead of the curve. Get ready for a transformative journey